Hello friends, today we are going to discuss about protection of women from sexual harassment at workplace, Act 2013, Part 2. To watch Part 1, visit my YouTube channel. I'm Dr. Suresh Badmat, Professor of Psychiatry, working at NIMANS, Bangalore. In this video, I'll be discussing about an important legislation, that is, the Sexual Harassment of Women at Workplace, Prevention, Prohibition and Redressal Act 2013. In simple word, it is also called as POSH Act 2013. That is, Protection of Women from Sexual Harassment. This legislation was passed on 23rd April 2013 in India. That is a very important legislation. On 9th December 2013, the legislation came into force. The rules were drafted and implemented. What is the preamble of this legislation? The preamble very clearly says, this legislation is to provide protection against sexual harassment of women at workplace and for the prevention and redressal of complaint of sexual harassment. So what is the legal framework which has been proposed here? The legal framework can be traced from the Convention on Elimination of All Forms of Discrimination Against Women. This is the United Nations Convention, which was proposed in UN in 1979. In simple word, it is called as CEDAW. However, India ratified this on 25th June 1993 after 14 years. Once we have ratified, we should have complied by making certain important legislation. However, we made certain legislation over a period of time. Although this CEDAW, that is, Convention on Elimination of All Forms of Discrimination Against Women, is considered as an international convention on rights for women across the globe. That is at the international level. What about the Constitution of India? In the Constitution of India, the fundamental rights are clearly enumerated. The fundamental right, which talks about right to equality under Article 14. Not only that, Article 15, prohibition of discrimination based on gender. Right to practice any profession under Article 19. Under Article 21, right to life, liberty, and to live with dignity. These are the very important articles under the Constitution of India. Although there are many other articles which are the obligations of the state, which is under the director principles of states. That means it is left to the state. Unfortunate, but some of them have been clearly has been delineated under the fundamental rights, and it is the duty of the state to provide these rights. Let's look into this legislation. This legislation has 8 chapters divided into 30 sections. Let's look into each one of them. Chapter 1 has section 1 to 3, which talks about definition, preamble, and for whom this legislation is there. Of course, this legislation is applicable only for women who has undergone sexual harassment at workplace. Chapter 2 talks about is basically the section 4, which is there, constitution of internal complaint committee. Further, chapter 3 talks about constitution of local complaint committee. Here, there are 2 important statutory bodies have been formed. One is internal complaint committee under chapter 2. Under chapter 3, it is local complaint committee. This internal complaint committee will be there in every workplace where the employees are more than 10 or more than 10. Whereas local complaint committee is at large in a district where if there is a working place where less than 10 members are there, this local complaint committee will be formed, which is common to every person in a district. Further, chapter 4 talks about complaint. Who can give the complaint? How to give the complaint? Those are the issues discussed from section 12 to 18. Chapter 5 talks about inquiry into complaint. How the complaint should be received, how to do the inquiry. All those issues are discussed here. Chapter 6 talks about the duties of the employer. to protect the woman, what she should do. What are the important steps he can take? What are the workshops, awareness programs to be done? And if he does not have internal complaint committee, what are the punishments that has been discussed? Chapter 7 talks about the duties of the district officer. That means a district officer will be nominated across the districts. And those people will be important people who will take the cases to the local complaint committee. And finally, chapter 8 talks about miscellaneous. Let's look into each one of them and see how this legislation plays an important role at workplace for prevention, protection of women from sexual harassment, and how the redressal is done when there is a sexual harassment complaint. First and the foremost, we need to know for whom this legislation is. This legislation is for women. That means for an aggrieved woman, this law plays a role. Aggrieved woman means in relation to a workplace. That means aggrieved woman cannot be any other person. It should be with regard to workplace. A woman of any age, that means a child, can also be an aggrieved woman. That means a woman of any age, whether employed or not. That means, for example, in a hospital, a patient who is a woman who walks into the hospital harassed by the people working in the hospital. Hence, a woman of any age, whether employed or not, who alleges to have been subjected to any act of sexual harassment by the respondent. So that's the very important you need to understand. Any age, any woman, either employed or not. Another important concept is aggrieved woman in relation to dwelling place or house. A woman of any age who is employed in such a dwelling place or house. Simple word, a maid. At your home, you may hire one or two maid. One may be for cooking, another maid may be for cleaning. Maybe other 3, 4 may be there. So again, it's a workplace. Hence, a woman of any age who is employed in such a dwelling place or house. So both are covered under this legislation. So let's be very clear. If you look at this, aggrieved woman either may be working in that place as an employee or else visiting to a workplace, maybe a university, as a student, maybe internee, maybe a parent, a lady who is gone to visit that place. All those are considered as aggrieved women. With regard to working, it can be domestic worker at home or a small place of working. It can be, she may be a regular employee or a temporary, ad hoc, daily wager, whatever name it can be called as. It may be for remuneration, maybe voluntary basis, or any otherwise, whatever name you can call it as. Employed directly or through any agent. Further, a contract worker, probationary, trainee, apprentice, any other name you can call it as. An aggrieved woman in a workplace can be employed or may not be employed, or she may be visiting that place. All those people will be considered as aggrieved women. Now, let's understand what is sexual harassment. We need to define this. Sexual harassment, as defined by the legislation, it clearly says unwelcome act or the behavior. Here, it may be one or more of these acts or behaviors, such as physical contact or advances, a demand or request for sexual favors, making sexually colored remarks or showing pornography, any other unwelcoming physical, verbal, or non-verbal conduct of sexual nature. Please remember, it starts with unwelcome. If it is welcome, it takes a different connotation. It should be unwelcome acts or behavior. It's very specific, unwelcome by the woman. That is very essential. It can be physical contact or advances, any demand or request of sexual favors, or making sexually colored remarks, showing pornography, any other unwelcome, again unwelcome physical or verbal, non-verbal conduct of sexual nature. You need to understand this unwelcoming. So, you need to remember this. Sexual harassment is an act or a behavior that is unwelcoming, sexual in nature. It is very subjective. Although it is subjective, the woman who is working there is suffering. Hence, even it is a subjective experience, the case will be taken. It is not the intent, it is the impact which matters. You may say, I just casually made a remark. I did not add an intent to do that sexual harassment. It is the impact on the woman which matters here. Often, this harassment occurs in the power matrix. That means already a man in our society is at the higher power. Not only that, he may be also superior authority. Of course, all high posts are taken by men. You take our parliament, both, maybe upper house and lower house, maximum are men. Women are least represented. That means men are at power. However, culture cannot be an excuse. I am from a urban area, and this is the way is in my culture, in my religion. This is the way I behave with the woman. That cannot be an excuse. It is an unwelcoming behavior. It has to be sexual in nature. It can be a subjective experience. It is the impact which matters. It is not the intent. That is how the sexual harassment has been defined. Let's look at the difference between welcome and unwelcome. Unwelcoming means unwanted by the woman. And it feels bad for that lady. It is one sided. Whereas welcome is wanted, feels good, it is two sided. Both man and a woman, it is a reciprocal reaction is there. In unwanted, unwelcome, the woman feels powerless. It is invasively power based. It is invading into her space or privacy, invariably demeaning. It results in a severe impact of sadness, anger, frustration, and leads to negative self esteem. Whereas welcoming is where she also feels in control, feels safe. It is equal because reciprocal reaction is there. It is open. Both invade into their space, appreciative, feels good, happy, and a positive self esteem. So, that is the difference between unwelcome and welcome that you need to understand. In the whole sexual harassment stands on the premise unwelcome, and it is a subjective experience of the woman. It is the impact on the woman which matters, not the intent or the culture matters. So, the issue of welcome and unwelcome can be dynamic in nature. Why I am saying this so? Woman may be in a dilemma when a man makes an advance. That means it can be construed as a welcome, or she has not thought about this issue. The man continues to believe it is welcome. However, over a period of time, she may feels it is unwelcoming and she does not like this. That may become unwelcome. So it's a dynamic in nature. But when she says no means no, that means unwelcoming. When she says it's I don't want, that means it will be construed as a sexual harassment. Hence, you need to be very clear about this. It is dynamic in nature. Although we may say, for a particular instances, it may be considered as a sexual harassment considering the event per se. Some of them may be welcoming and some of them may be considered as unwelcoming. Although it can be considered for men, this legislation is biased. Of course, it will be biased because majority of the women who work have the prevalence. If you look at it, is around 30 to 40% of them suffer from sexual harassment. Hence, this law is to protect women from sexual harassment. Although men can be considered as maybe biased, they may be the victim also. But this law protects women because at this point of time, if you look at our society, the society is powered and also more power is given to men than the woman. Hence, this law tries to bring in gender equality to see how we can protect women at the working place. Now look into is prevention of sexual harassment at workplace. Prevention here is not only with regard to prevention, it also, if it occurs, or is it present in relation to or connected with any act or behavior of sexual harassment. That means if a person wanted a sexual favor from a woman and it is implied or explicitly said promise for preferential treatment or threat of detrimental treatment or a threat about her present or future employment status. Here, you need to prevent these kinds of episodes. Providing implied or explicitly telling a woman, I will provide you promotion, or if you don't comply, I will demote you, or I will not make you permanent post. That kind of is also considered as sexual harassment. And this interferes with the work or creates an intimidating, hostile environment for the woman. Humiliating treatment is given to that woman, and it affects her health and also safety, and it affects her mental health severely. And to summarize, my dear friends, the whole premise of this legislation stands on unwelcome acts or behaviors. It may be one act or multiple. It can be physical, it can be verbal, non-verbal conduct of sexual in nature. It can be quid pro quo. That means literally this for that. That means if you comply with the sexual favor, I will promote you. If you don't comply, I will demote you or I will throw you out of the job. That is quid pro quo. Hostile working environment. Respondent can be a male or a third gender or a female. And this legislation is for a woman, a aggrieved woman. Here the intent does not matter. It is the impact which matters to the woman. Culture cannot be used as an excuse to say that it is not a sexual harassment. Now let's look into the workplace, because the whole legislation is prevention and protection of women from sexual harassment at workplace and also the redressal mechanism. So workplace means it can be governmental place or a government working place. It can be public sector, corporation, cooperatives, or a government undertaking. It can be private sectors, organization, ventures, societies, trust, NGO, or whatever name you can call it as. It can be commercial, vocational, educational, sports, professional, entertainment industry, industrial, health-related, financial activities, including production, sales, providing services, distribution. Anything can be considered as private sector. Includes hospital, nursing homes, sports facilities, institutes, universities, college, place visited by the employee, including while on travel, including transportation provided by the employer. A dwelling place or house also is considered as a workplace. This is under organized sector. That means here it is well organized. There is a place well defined. It can be transportation place. It is a place where a woman goes for working. Maybe extended part of the place of working can be considered as organized. Unorganized sector is an enterprises which employs less than 10 workers. An enterprise owned by an individual or self-employed workers engaged in the production or sale of goods or providing services of any kind. So that is unorganized sector. So this legislation applies both for organized and unorganized sector. Let's look into the employer. The employer means workplace of either government, local bodies, or a private workplace, dwelling house where a Mr. or a Miss hires a lady for work or a housemaid. Here the workplace also head office or a branch office or an extended workplace. Private workplace is a person responsible for management, supervision, and control. Dwelling house, a person who employs or benefits from the employment. So these are the employers, and they will be held responsible if they don't have internal complaint committee, and they need to protect the woman from sexual harassment. And if there is a complaint, the redressal mechanism should be in place. Let's look into the two important committees, that is complaint committees. One is internal complaint committee, another one is local complaint committee. The first one is internal complaint committee. It has Minimum 4 members, it can be more also. One is a chairperson. The chairperson will be a woman working at a senior level as an employee in that place. If not available in that place, nominated from other office units, departments, branch office, workplace of the same employer. That is the chairperson. She will be holding the office for at least 3 years. 2 members, minimum 2 members from among the employees committed to the cause of women, having legal knowledge, experience in social work. They are the 2 members. It can be more also. And a member from among the NGO associations committed to the cause of women. She may not be working in that place, or he may not be working in that place. A person familiar with the issue of sexual harassment, that is the person you are going to consider them as a internal complaint committee, and they will be there for at least 3 years. Hence, to summarize, the chairperson is a senior female employee, at least 4 members, one external member, 50% should be females. That's very important. It has to be set up by the chief of the institute, organization, department, or the employer. If there is a complaint against the chief of the institute, that is one of the important person, against him it is there, then the case needs to be referred to the local complaint committee. I'll be discussing about the local complaint committee shortly. The Act requires all workplaces to set up an internal complaint committee to address the issue of sexual harassment. There will also be a local complaint committee for each district, which complaints can also be filed there, especially if the complaint against the head of the department or the head of the institute, and that complaints need to be directly taken up by the local complaint committee. And if it comes to the internal complaint committee, that can be referred to the local complaint committee. What is this local complaint committee? Here, there will be a chairperson, a member, 2 members, and ex officio members. The chairperson is nominated among the most eminent women in the field of social work committed to the cause of women. Member is a nominated from amongst the women working in the block, taluk or tehsil or ward or the municipality in the district. 2 members nominated from amongst NGO, association, person committed to the cause of women or familiar with the issue relating to sexual harassment. And at least one must be a woman, at least one must have a background of law or a legal knowledge. Ex officio member, the concerned officer dealing with the social welfare or women and child development in the districts. That is local complaint committee, my dear friends. With these two important statutory bodies, one is internal complaint committee and local complaint committee, which are being established at every district. Now let's look into the complaint. The complaint needs to arise from the woman, that is aggrieved woman. She need to give complaint to the sexual harassment committee, either internal committee or the local complaint committee. She has to give in writing with 6 copies, along the documents, witnesses. If she has the witnesses that need to be named. And these complaints should be within 3 months of the last incident. If there are multiple incidents, that maybe one of the last incident will be considered. From there, the 3 months is the time. However, the local complaint committee or the internal complaint committee can extend another 3 months. That means from the last act, 6 months can be given under the legislation. Committee needs to give a copy of the complaint to the respondent and also to all the members within 7 days after receiving this complaint. The respondent or the accused need to respond to the complaint within 10 working days. And during the complaint, when we are addressing it, principle of natural justice procedures need to be upheld and followed. Let's look into this complaint committee. Who can give the complaint? If a person has physical incapacity because of various reasons, the relative of the complainant or the friend, co-worker, officer of NCW, that is National Commission for Women, State Commission for Women, any person who has a knowledge of the incident with the written consent of the complainant, the complaint can be given to the committee. In case of mental capacity, Incapacity, that means a person with mental illness who is unable to decide. And she is aggrieved woman, a relative, a friend, a special educator, psychologist, psychiatrist, guardian, nominated representative, authority who cares. The complainant is receiving treatment. That person also, on behalf of the complainant, can give the complaint. In case of the complainant's death, how it is possible? There is a sexual harassment and she commits suicide. That is, death by suicide is there. In such a scenario, the family member or the legal guardian can also give a complaint. In case complainant is unable to file the complaint for any other reason, that means by any person who has the knowledge of the incident with written consent of the woman can be given the complaint and they will be constituted as the complainant. That means the scope is given so that other people can represent on behalf of the woman who is suffering, but a written informed consent to be taken from her. Let's go through each one of them. Complaint content. What should be the content? There is no any format has been given. However, when a complaint is filed, description of the incident, what place, what was the date, what was the timing, whether it was single, multiple, who are the witness, what was the respondent's name, what is he working, and what authority under he is working, parties working in the workplace, what are the evidences you have, witnesses you have. Those need to be mentioned in your complaint letter. That should be complaint content. Hence, it is kept open because sexual harassment is very woolly. It is unwelcome. It is a subjective experience. It is the impact on the woman which matters. Hence, there is no any format. Hence, it is an unstructured complaint letter. Before giving the complaint, collect the evidences. Evidences with regard to document the date, time, place, and the context. The colleagues, who are the people who are there. Those are the things you need to document. And if you have received any messages, emails, logs, please keep them. Don't delete them. Take printouts, audio video recordings. If you have recorded any audio, if you have recorded any video, and if you are able to get hold of the CCTV recordings, documentary evidence, material evidences, talk to your colleagues. A colleague who is confiding, a person who is going to keep it confidential, check whether there are any other victims in and around the workplace. And keeping all these evidence, communicate your grievance. Very essential. Let's look into the 6 stages of inquiry, how the inquiry takes place under this legislation. There are 6 stages. The stages are receipt of the complaint, planning and preparing for the inquiry, interviewing the complainant, the respondent, witnesses. Once you have done this interview, you need to come to a conclusion. You need to reason out the punishment or else exonerating the respondent, findings, recommendation, and there should be a logical explanation for that. And finally, preparing the report. These are the important 6 stages which have been to be carried out when you are doing the inquiry. Let's look into each one of these stages. There are 6 stages. As I mentioned, stage 1 is receipt of the complaint. Stage 2 is planning carefully. Stage 3 is interviews. Stage 4 is reasoning. Stage 5 is finding and recommendation. And stage 6 is report. If you look at the stage 1, it has 5 steps. In the step 1, receive and acknowledge the complaint. Meet and talk to the complainant to explore whether an option of informal resolution is there. Informal resolution of the complaint, where you ask the complainant what she is expecting, why this complaint is there, how the complaint occurred, what is the subjective experience, what is the impact of the harassment, and what she means by sexual harassment. And see whether what is the redressal mechanism she is asking for, whether informal way of settling the complaint can be done. However, monetary benefit cannot be given when you're doing the informal mechanism or even the formal mechanism. Step 4, if the informal mechanism doesn't work, the formal mechanism can be taken into account and the process starts. Both the respondent and the response will be taken into consideration and moves into the stage 2. That is planning. Here you have to prepare the file, keep all the documents, give a copy to all the members, call for a meeting, and the documentation is done. Moving to the stage 3, it is the interview. You need to interview the complainant, the respondent, and the witnesses. You need to assess the completeness of the information collected. Check whether there are any material evidences like audio recording, video recording, digital trail, SMS, emails, phone call logs. Once you do the collecting evidence, you need to reason out. You need to logically explain, analyze, and assess the information gathered during the inquiry. Create a timeline to help and establish the sequence of events related to the complaint. Compare the similarities and difference within each of the statements made by the interviews. Once you do the stage 4, move to the stage 5. Finding and recommendation. That is, what is your finding? What does the committee decides? And how the committee, whether it is on majority basis, how the logical explanation is given. And finally, giving the recommendation and the report writing. These are the important steps which needs to be undertaken when the inquiry is conducted. Although 6 stages have been discussed, let's understand the procedure. In the procedure, the complaint needs to be placed before the committee. The respondent has to give the response and the case hearing starts. Committee will record the statements of both the complainant and the respondents and also collect the documents, interview the witnesses. During the procedure, no legal representatives will be allowed to represent either the complainant or the respondent. The Act provides the option of settlement between the aggrieved woman and the respondent through conciliation process. During this conciliation, it has to be done only on the request of the woman, and there will be no monetary benefits will be given or a compensation will be given to the woman when the informal settlement is done. Remember this. If there is harassment is proved, the government service rules will dictate what will be the punishment. The committee can take either the written apology, warning, reprimand, withhold promotion, suspend or recommend for punishment, or cut, increment or transfer, suspend or dismiss. But this recommendation will be given to the employer. The 3 months leave for the woman can be granted during the procedure, and this is a paid leave. However, the woman can also request to be transferred to the other department where the respondent is not there, or else the respondent can be moved out of the place and the respondent will be not monitoring the person who is aggrieved. Here, the case will be taken based on the probability of the evidence. That means civil case evidence will be taken, not the criminal case one. And the identity of the aggrieved woman and the respondent and witnesses will be kept confidential, and it will not be published anywhere else. Case should be decided within 90 days, that is 3 months. If one party does not attend the case for more than 3 times, case proceedings can be quashed or ex parte decision can be taken. Once the decision is taken, appeal can be done within 3 months. Either the respondent or the aggrieved woman can appeal to the court. This is the procedure which I would like to discuss here. Both when the complainant has given and the respondent has given the response, either there will be informal or formal can be considered. Informal is basically conciliation, and here the request should be from the woman. And again, you will explain as a committee member, there is a formal and informal, and if she chooses to be informal, the conciliation process starts. And it has to be, again I'm telling, it has to be woman who has to choose the informal, not the respondent. And the respondent will fulfill the obligation as agreed upon what the woman has asked. It may be apology, it may be giving written apology, or the punishment which is through the conciliation process has been agreed. By chance, if the respondent fails to fulfill his obligation as agreed upon, an inquiry of formal will take place. What is this formal? Either the internal complaint committee will go, or else it can be referred to local complaint committee. One copy of the complaint to the be submitted to the respondent, to which the respondent needs to reply within 10 days. So the formal procedure starts. Again, inquiry report to be completed within 90 days, either by the ICC or LCC. Report of the findings to be submitted to the employer or to the district officer, or and also to the concerned parties, both the respondent and the complainant. If the complainant is not upheld and inconclusive, the recommendation should be given to the employer. If the complaint is upheld, the recommendation should be implemented by the employer, and within 60 days it has to occur. If not satisfied, either by both the parties, they can appeal to the court, that is the tribunal court, within 90 days. That is how the procedures have been clearly laid out. Let's look into the timeline as per this POSH Act of 2013. Submission of complaint within 3 months of the last incident. There may be multiple incidents. The last incident will be considered from their 3 months. Maximum other 3 months can be given by either the internal complaint committee or the local complaint committee. Notice to the respondent has to be given within 7 days of receiving the complaint by the committee. Completion of inquiry should be done within 90 days. Submission of report by the ICC or LCC to the employer should be done within the 10 days of completion of the inquiry. Implementation of the recommendations by the committee to be done by the employer within 60 days. Appeal. Either the complainant or the respondent can appeal to the tribunal within 90 days of the recommendations. What if there is a false complaint? False complaints. In case of a malicious complaint or a false complaint, the committee may take an action against the woman, so-called aggrieved woman. However, simply not being able to prove an allegation will not mean that it is a false complaint or a malicious complaint. For a malicious complaint, there should be a clear intent to tarnish the image of the respondent. In such a scenario, only the false complaint will be considered. Let's look into the punishment that could be awarded by the complaint committee, either the internal or the local complaint committee. The punishment can be as based on the service rules, either maybe central service rule or the state service rule, or maybe even if it is the private organization, if they have service rules, that will dictate. If there is no service rules does not exist, disciplinary action can be such as writing apology, reprimand, warning, censure. Withholding promotion, withholding pay rise, bonus, increment can be done. In serious cases, termination of employment, or else asking the respondent to undergo counseling, maybe gender sensitivity training program, workshops, community services can also be considered. Further, the complaint committee can also ask for deduction from salary as in compensation for mental trauma, pain, suffering, emotional distress caused by, and the medical expenses incurred for this mental trauma can be reimbursed from the respondents. The loss of career opportunity can be considered. The income and the financial status of the respondents play a very crucial role. If the amount is not paid, it can be recovered as an arrear of land revenue can be considered here. That means the punishment has been clearly said. But however, please remember, there will be no monetary settlement can occur here. It is only for the compensation for the mental trauma or physical pain which has occurred that will be given here. What about the confidentiality? Here, there is an obligation of confidentiality has been placed for both the committee and also either for the complainant or the respondent. Identity, address of the complainant, respondent, witness, information pertaining to the conciliatory process, inquiry process need to be kept confidential. That is very essential. If there is a breach of confidentiality is there, it may invite 5,000 rupees penalty. That can be collected by the employer. However, there is an exception. Dissemination of information regarding the justice secured without disclosing the name, identity, address, particulars of the complainant or the respondent or the witnesses can be considered, but means they cannot be told. However, without disclosing the name of the complainant and the respondent and the witness, as a case example can be told, keeping confidentiality. What is the obligation of the employer under this legislation? The employer need to formulate anti-sexual harassment policy, display within the organization the penal consequences of the sexual harassment at workplace, and it will be considered as a major punishment, and it will be taken seriously. And the employer need to create a ICC, internal complaint committee, at each location and display their contact details. Sensitization, training of the employees, and also the ICC members. Provide administration support and monitor timely about the working of the ICC. And all logical support should be given to the internal complaint committee. That is very essential. Mention the number of cases filed, disposed under this act in the organization's annual report. Help the aggrieved woman in registering the criminal case if she so desires. Or informal conciliatory process can be taken if the woman desires so. To conclude, my dear friends, prevention of sexual harassment at workplace for women, this Act 2013 is the first step for bringing gender sensitivity and also gender equality at the workplace. However, this law also can play a double-edged sword. Many employers may not hire a woman considering this legislation can backfire them. However, this is not going to be a major reason not to employ women. However, this law casts obligation on the employer to make the working environment safe by setting up of internal complaint committee, providing logical support to the internal complaint committee, to set up a redressal mechanism within the organization, and also the policy against sexual harassment to be in place so that women can work in a safe environment. Thank you very much for giving your valuable time. Stay safe.